What's going on, everybody? My name is Andrew, and today I want to talk to you guys about the N12 form, what it is, and how we use it. Now for this video, I want us to just jump into the form really quickly and just take an overall look at it. Now, as we look over the N12 form, you're gonna see that it is actually a relatively simple form. It's not a lot to select here, and even though there's a lot of options that may show up, there really is only two things that you're gonna be selecting from. So obviously, when you're going to fill out the form, you wanna make sure to, again, fill out your name, make sure you fill out your tenants' names or names if there are more than one tenant, and make sure to fill out the address correctly and in accordance to the unit that you're going to be addressing, because this could affect you down the road. And the next section that we have to fill out is very simply the termination date, which cannot be any earlier than the end date of 2 full rent cycles, assuming your tenant is on a month-to-month basis. Now, moving further down onto the next section, this is where we're going to be selecting our option, which we're going to declare our intention. So if we look at reason number 1, this is if you as a landlord or one of your family members is interested in taking over the property for at least 1 year. Now, the second reason is if you have listed your property for sale and have a purchase of sale agreement where it stipulates that the buyer or one of the buyer's family members wants to take over the property, and again, this has to be for a period of 1 year. Now, by serving this notice, you as a landlord effectively agree to either find the tenant another suitable, comparable, or agreeable place for the tenant to move to, or you're effectively going to have to pay them 1 month's rent by the termination date in that notice. Now, there are a few stipulations that I want to mention right off the bat. Number 1 is that you cannot use this form to terminate a tenancy before the last date of their tenancy term. So if they still have 6 months on their lease, you cannot evict them with an N12 before that period of time has elapsed. Now, the second thing is that you cannot use this notice based on your intention to sell the property to someone who's going to take possession themselves. You must have an established purchase of sale agreement already in place with the stipulation that the buyer is wanting to take possession for themselves. And by serving them this form, you technically give the tenant the right to give you a 10-day notice of their intention to move out using an N9 form. And that's basically it, guys. That is the N12 form. But although this form may sound pretty simple, it's actually really complicated based on how the form is commonly being used. So now let's talk about what could happen when using this form. Let's say you're a landlord and you want to take over the property. You serve the tenant with a notice using an N12. Assuming you fill everything out correctly and your tenant cooperates, they will move out at the end of that 2-month cycle and you will take possession of the property. Now, if they refuse to leave, you will need to file with the board using an L2 and you'll pay that $201 filing fee. And a good thing to know about using this form is that immediately after you serve it, you can technically file with the LTB. Now let's assume you file your L2 and you end up getting a hearing notice and you attend the LTB. What do you have to do? You have to go there, you have to present your case. Whatever the reason that you selected in your N12, you have to be able to substantiate it and present your case to an adjudicator. Now let's assume that the adjudicator agrees with your reasoning. They will order the tenant to leave the property, and if they don't leave by the date that they ordered, you will be able to apply for eviction. After all of that song and dance, let's just say everything moves smoothly and then you take over the property and now it's yours. A lot of landlords use this form simply as a means to evict tenants so that they can take possession of their property or their rental unit. And where it becomes really sticky is when they or their family member that was supposed to take the unit doesn't, and instead they re-rent it or basically renovate it so that they can sell it for a higher price. Whatever the case might be, if they did this with the intention of doing so, that would be considered bad faith. Now, if a landlord effectively evicts a tenant because they wanted to take the property and they do not end up doing so, the tenant can file a T5 against the landlord, which is for the termination of a tenancy in bad faith. What might an adjudicator constitute as bad faith? And to answer that, we're going to be looking at previous scenarios and what happened to their verdicts. In one instance, a landlord terminated a tenancy with an N12 only to later renovate it and list the property for sale. When this case went to trial after the tenant found out and filed a T9 against them, the following argument happened. The tenant argued that the landlord had no intention of moving into the property and only wanted to sell it. The adjudicator ordered that in this case, the landlord did act in bad faith and they were ordered to pay $7,000 to the tenant. And this number came from calculating the 1-year difference in rent that the tenant had to pay at their new place with the consideration of some moving costs. And remember, this was a situation where the landlord was found to be acting in bad faith. Now, in this situation, the adjudicator further stated that if the landlord wanted to sell the property, they should have listed the property for sale first with the tenant still there and then serve the tenant with an N12 after they had an agreement for purchase of sale with the stipulation that the buyer wanted to take over the property. But a lot of landlords will argue that this will take too long and they effectively wouldn't get what they need, so they end up using this form in unethical manners. Now, in reference to another one of these cases that we dealt with last year, we were asked to serve an N12 by a purchaser of a property that we were selling. And the buyer had stipulated to us that they had every intention to move into the property and take it for their personal use. But what ended up happening was the buyer simply fixed up a few things in the property and then rented it out for a much higher price than we had it. Now, the previous tenant found out and filed against us, who were his landlord at the time. Now, in this case, the adjudicator found that there was indeed bad faith that took place, but it was not on our part because the seller did in fact stipulate that they did want to take over the property and instructed us to serve the N12. Now, in this particular situation, we were not found liable and the tenant was instructed to file against the new property owner. And this is why it is very important that if you are serving N12 for this reason, that it is clearly stipulated in your purchase of sale agreement. Now, the conclusion to this case was basically that the new owner would have to pay the difference of the 1 year of rent that the tenant had to pay at their new place. Plus, I think they said they were going to add in some moving costs, but because it hadn't gone to trial yet, they weren't calculating it. Now, all this is to say that we have looked at several cases similar to these, and the truth is the reasons behind the bad faith are all pretty similar, as are the repercussions set out by the board onto the landlord. And it's usually ordering them to pay 1 year's difference in the rent that the tenant has to pay plus some moving costs. But what I think is sometimes interesting here is to look at how some of these landlords have successfully defended themselves, or if you don't keep the property, are you always acting in bad faith? Now, in one of our previous cases, we saw a landlord simply state and was also able to substantiate that their circumstances had simply changed. Now, if you're a landlord and you intend to move into a property because you have a job that you're going to take nearby, then afterwards your tenant leaves, your work situation changes and you're no longer able to take that property on. What this landlord simply did was they called the previous tenant and offered the unit back to them. But understandably, the tenant was unable to take the unit as they had already signed a lease somewhere else. But regardless of that, the tenant was still obviously upset and they filed against the landlord using a T9. But when the hearing took place, the adjudicator ruled in favor of the landlord because of their intention and ability to prove it. That particular landlord was able to prove that they did have a job offer initially and that he later on got a better job offer elsewhere, and that he offered the rental unit back to the tenant and documented it appropriately. Now, to conclude that particular case, the adjudicator basically stated that just because the landlord was not able to take their job does not mean that they had to be locked into living at that specific property for a year. People's circumstances are indeed allowed to change, and it was the right thing to do when the landlord did offer the tenant back the property. And because the landlord was able to substantiate all these things, the adjudicator did not believe that the N12 was served in bad faith. So what does this all mean? Well, it basically means that if you are serving this form, you really need to be as transparent as possible about your intention. And if you are a landlord and want to take over the property because you want to sell it, you're much better off settling with an N11 and paying your tenant in a cash for keys manner in order to proceed, rather than finding yourself acting in bad faith just to evict someone from their home for your profits. There is nothing wrong with paying someone when you stand yourself to make money. As a landlord, your biggest advantage is your financial leverage. Make sure to use it. All right, everybody, so that is our experiences on how to go about using the N12 form. We'd love to hear what your experiences are in the comments below. If you have any questions about how to use landlord-related forms, we'd be happy to answer them. We're going to leave some information about us in the description below. As always, make sure to like this video, subscribe to our channel, and we'll see you on the next one.